Good evening. I am Noah Kipliogman, Chair of the City of Kingston Rent Guidelines Board. It is September 16th, 2024 at 6:15 p.m. I am calling this meeting to order, and I will start with a roll call of members. Noah Kipliogman, present. Diana Lopez Martinez.
Here.
Mia Inouye.
Here.
Anthony Jr. Tampone.
Here.
Michael Tierney.
Here.
Carol Soto.
Here.
Arlene Puentes.
Here.
Lee Dodson.
Here.
And we have one vacancy. Our business today is to certify the guidelines established by this board for the 2024 to 2025 guideline period. The law does require this board to file its findings annually. And so having decided our adjustments for the year at meetings in June, we are set to file a formal explanatory statement and findings of the Kingston Rent Guidelines Board in relation to the 2024 to 2025 rent guidelines allowances for apartments under the jurisdiction of the Emergency Tenant Protection Act of 1974 in the City of Kingston. We have had shared with us a draft explanatory statement prepared by our colleagues at DHCR. Thank you so much. I would like to suggest a couple of revisions that I will outline, and then I will make a motion to adopt this explanatory statement as revised by the specific edits that I'm about to make. Is that what I'm doing? Thank you. I would propose the following amendments. On page 3, I would remove all of the bracketed indications of T or LL because they include some errors of fact. And similarly, right, so they're under the June 11th public hearing, there are bracketed T's and LLs. Also under the June 15th public hearing, there are T's and LLs in brackets. I would omit all of them. In addition, on page for the cash flow, on page 8, I would amend the first sentence in the description to say changes in cash flow, and then omit before and after depreciation. So it just says changes in cash flow for the 16 tabulated buildings. And then buildings are presumed to be in a better financial position when they spend a lower percentage of income on expenses. From 2021 to 2022 cash flow, and then I would omit before depreciation. So cash flow increased from 26.13 to 27.83 and increased again in the period 2022 to 2023 from 27.83% to 31.48%. And then I would remove the entirety of the following sentence because cash flow after depreciation is a nonsensical concept, right? Depreciation is, by definition, not a cash activity. And then in the table, I would remove the line and the data under cash flow that starts after depreciation. I would just remove that line And similarly, cash flow as a percentage of income, I would remove the line after depreciation and the data there. The reason to do that is because depreciation is not a cash expense, and so adjusting cash flow by a non-cash activity is just not, it's not a useful thing, and we should not include things in our findings that just seek to have the effect of confusing the communicative efficacy of our findings. I move that we accept the explanatory statement and findings of the Kingston Rent Guidelines Board in relation to the 2024 to 2025 rent guidelines allowances for apartments under the jurisdiction of the Emergency Tenant Protection Act of 1974 in the city of Kingston, as drafted by our colleagues at DHCR and as amended as I just described. I'll take discussion, questions.
I have a
comments.
question.
Second. We need a second. Do we need a second before we discuss it, or can we discuss it?
We do.
So I'll wait.
Second.
Mie seconds. Carol.
Oh,
Not
yes.
Carol.
Could you explain? This is, does this document do something, or is it just for the record so that it'll be on our on the website?
April, can you answer that question?
So is there any negative to doing it? Is there any positive or negative? It's just information? Is that information? Okay, thanks.
Any other discussion? I'll call the question. Noah, I vote aye. Deanna,
Aye.
Mie,
Aye.
Junior,
Aye.
Michael,
Aye.
Carol,
Aye.
Arlene,
Aye.
and Lee.
Aye.
The motion carries. Thank you. We turn now to, yeah. I did not provide specific line edits. I provided a vibe, but I can hand you this for the line edits, but I did not like cross out all of the bracketed things. But I can hand you this for the line edits. Yeah. Moving on to other business, I shared with this board before this meeting that we have a statutory responsibility to prepare and approve an explanatory statement and findings for each year that we make an adjustment. And we have not yet completed that process for the adjustment year 2022 to 2023. As you know, there has been some litigation about our decisions in that year. The appellate court of the third department appellate court upheld our ability to make the decisions that we did, and it vacated the order of the Supreme Court that had stayed our decision. Now that the appellate court has also certified this as a question that is relevant for the Court of Appeals, the highest court in the state of New York, to discuss. But as of right now, the Supreme Court order that vacated this board's 2022 to 2023 guidelines and fair market rent appeal, the order that vacated it has been overturned. And so our statutory responsibility as a board to file explanatory statements about our decisions is, to my mind, in effect. And so I think we have a responsibility to formally file our findings. We do not yet have a draft prepared of that. I would encourage us as a board to consider a motion asking DHCR to prepare uh, a, a draft of those findings and to schedule a meeting when we could review and approve and certify it, just to dot I's and cross T's on our work from 2 years ago, 3 years ago.
So you just made a resolution?
I don't think I made a motion just now. I just said a statement. So I move. Thank you. Appreciate it. I move that this board requests that DHCR prepare an explanatory statement for this board's review and approval in relation to the 2022 to 2023 rent guidelines allowances for apartments under the jurisdiction of the ETPA in the city of Kingston. And if that resolution passes, then I think we should move to scheduling a date. So, but the resolution is we request that DHCR prepares a draft explanatory statement for the 2022 to 2023 guidelines here. Is there a second?
I second that.
Deanna seconds. Any discussion?
Yeah, I'm fine with asking them to prepare a statement. I am concerned about this board making any move until the litigation is finished its way through the court. I know we thought that that was going to happen. It obviously is not finished yet. So I think it could be prudent for us to have the statement prepared with the caveat that this board makes no further move until the litigation is settled and all legal avenues are exhausted. I don't want to see us making statements that seem factual to the public that then become overturned by a court.
I appreciate that, Junior. Thank you. Other comments?
I have a question. I want to know if April's, if April's comments are in the minutes, because right now she made several comments, and I want to make sure that they're in the minutes, or ask whether they are in the minutes. It would be part of our official, the official minutes. Yes? Okay.
Thank you.
So would it be appropriate to ask April's opinion on the matter for the resolution?
April, do you want to express your opinion to the board?
Or you can just tell me whether it's not appropriate. I just want to make sure I.
As I expressed when I spoke to Noah, you don't have the initial one because of the litigation. And the second, you have last year's, it was done. The second one was held at the same time the first one was held. I would suggest that you might want to consider, the agency can prepare it for you. That's not a problem, but I don't know that you want to have it approved before the litigation is completed. And I did check today, and we don't have any dates for the Court of Appeals argument or what their actual question is that's been certified to them. So given that litigation, I would suggest you hold off on actually approving it, but I have no problem having, asking the research and analysis group to prepare a document for your review.
And what are your reasons for asking us not to approve it just yet? What are the reasons for asking you? What is the downside of approving it is what I'm asking.
At this point, although there is a Court of Appeals case, the actual question that was certified to the Court of Appeals wasn't stated. So I don't have a copy of what they were certified for. If it has to do with the actual process you're doing, I'm just going with what we've told you in the past, which is that one at the time, we asked the board not to certify because it's off whatever the first one was, right? So if the first guideline gets overturned, then you've done an explanatory statement off of that that could be, just make it more complicated. The board is at liberty to do whatever the board chooses to do.
So the reason not to do it is because things can get more complicated? Is that what I'm at? Is that
Yes.
what you're saying? So
Yeah, It's a
things,
possibility. I'm not saying it will happen.
so things
I'm
will
just
get more
saying it's a possibility.
complicated for whom? For the public, for the board, for you?
For the public, for the tenants, for the owners, for this board, you may have to come back and redo all of those numbers. I don't know. It's more of asking that you just keep a status quo as opposed to moving forward. But the board can do, obviously, you're an independent board. You can do whatever you choose to do.
I want to clarify what the status quo is, right? The status quo right now is that our guidelines for the 2022 to 2023 year are in effect.
Correct. Absolutely.
We just have not prepared a statement that says formally what they are.
No, you have, it is posted that that is what it is, the explanatory statement. The explanatory statement just explains how you got to your numbers. It doesn't explain what your numbers are. So your guideline is in effect. It has always been in effect since you all approved it. It's just the explanatory statement that has not been signed and approved.
So I would say that we should, consider, while the guidelines that we set are in effect, that we dot the I and cross the T. And then if the court decides that our guidelines were outside of the legally allowable decisions that this board can make, right, which the court may decide, the court may toss out the guidelines, they toss out the guidelines with the explanation statement. Like it's a package. And I'm just saying our package right now is incomplete, and we might as well seriously consider just like putting a bow on it so like the courts can do their decision making. There is a motion on the table to request that DHCR prepare a explanatory statement for the 2022 to 2023 guidelines year.
I will second that.
And it's been seconded widely. Do we have any other discussion, or would we like to call the question?
I did want to mention that when you file a FMRA, what has happened is that the landlord's answer has said that the board has never certified, even though we know that it is legal whether we have certified or said this or not. But
So it seems as though that April, it seems as though April has said very clearly that our guidelines are in effect, but we have heard testimony, and Carol has repeated that that there are landlords in our community who are saying that they can't take actions to follow their responsibilities under the guidelines until an explanatory statement is filed. I would say they're wrong about that, I think. Is that right, April? And so we might as well like let go of one more excuse, right? We can just like put a bow on it, and then like there will be one more reason for people to follow their responsibilities under the law.
I totally agree.
Are we ready to call the question, or is there other discussion?
April, is ORA, to your knowledge, doing anything different? Because if there's an FMRA filed and they are accepting the guidelines, then ORA should be responding to the property owner with the process, irregardless. Am I misunderstanding that, or is that how?
I actually couldn't tell you specifically. I know that they have begun processing the fair market rent.
We did hear that testimony from the public in June. Does the process, sorry, this feels very loud when I talk into it. Does the process look any different at ORA whether or not we file an explanatory statement?
Um, is there a, uh, by not, if the board does not file their explanatory statement, what is, uh, I guess, like, what could the legal repercussions for the guideline be? And what avenue would need to be taken to, create a, I guess I'm trying to understand, in light of the litigation, uh, what possible negative or positive impacts us making a move on this, item could be.
Not sure the answer to that. I'm not even sure I know the question, to be honest. If you're asking whether or not to do it, as I said, the board is welcome to have us create an explanatory statement. That's fine.
Mhm.
I am just sharing what has been previously shared by the attorneys handling your litigation, which at that point in time was to not do that. So
Sorry, I want to be clear that the attorney handling the litigation said that she had no opinion on the matter.
Oh, sorry, too loud, too close. If the, I know, I assume you're talking about the Solicitor General. If they have any opinion on it, I think that they, we should, if we're going to make a motion on anything, we should, ask the Solicitor General to, submit a statement to the board guiding us, on their, what they think the best course of action for us is to do.
And you're saying this should be done not, we could ask them to prepare an
I-
explanatory statement, and then before it is voted on by this board, you recommend,
Yeah, I don't think there's really any harm in them preparing the statement, but, I think, I don't know whether or not there could be harm in us making a move, while there's still litigation. I mean, typically every attorney says, don't do that. If the Solicitor General says that it's okay, then that's a different thing.
or
But,
has no opinion.
or yes, and then
Yeah.
that's a different thing, but I would like them to give us a statement, um, explaining that in one way or another.
Junior, I
Okay.
think that is a really good, I think that's a good idea. So I would say we should discuss and vote on the motion at hand, and then I would encourage you to propose a motion, I think, asking me
Yeah,
to ask our attorney to
yeah.
share feedback.
Fine with
Submit
that.
a written statement
And
to the board.
I will support
Yeah,
that motion.
yeah.
Any other discussion of the motion on the table?
Yes, we received two documents from DHCR, and one we voted on, that's done. Is the other one
That one's
a,
from me.
no, not yours.
Oh, no,
There
this
was-
one was from me also.
Oh, that's from you? What the hell is it?
It was. I took the liberty of preparing what I thought could be the beginning of a draft, but we are asking
For the-
DHCR to do that task because they're better at it. Any other discussion?
I move to call the question.
Do we need to vote on a move to? We just call the question. Noah, aye. Deanna,
Aye.
Mie,
Aye.
Junior,
Aye.
Michael,
Aye.
Carol,
Aye.
Arlene,
Aye.
and Lee.
Aye.
The motion carries. Junior,
I'd like to make a motion to ask Noah to, request that the Solicitor General, give us a written letter of guidance on our actions in regard to any and all matters that are covered by current litigation.
Second.
Can we narrow that to whether or not we should file an explanatory statement?
I mean, I would like them to, if there's anything else they want to comment on, sure, but we can also specifically ask for it about the explanatory statement. You know, I feel like that letter was probably going to be relatively brief, but you know, but you know, I don't want to miss something if it might be important.
Perfect. So the motion is the Rent Guidelines Board requests that NOAA ask the Office of the Solicitor General for a written note describing the current status of the litigation and any advice about whether or not to file an explanatory statement for the 2022 to 2023 guidelines years.
Yeah, I would just change describing to advising us.
Advising.
Yeah.
Deanna seconded. Do we have any discussion? Michael?
Yeah, I'm a little reticent to ask somebody who's representing us to provide in writing in a public document whether or not moving forward with something does or does not harm our case.
We could ask them to do that in
Executive
an
session.
executive session, to deliver in an executive session. So they would deliver it. I assume that they would deliver it to you, and then you would deliver it to us in executive session, right? Yeah, I concur with your concern. Yeah.
Any other discussions? It's been seconded. I'll call a question. Noah, aye. Deanna,
Aye.
BA,
Aye.
Junior,
Aye.
Michael,
Aye.
Carol,
Aye.
Arlene,
Aye.
Lee.
Aye.
The motion carries. One more piece of business is I would like to schedule a meeting for us to discuss the explanatory statement and the advice from council.
I have a question before you do that. What about this resolution that we got a draft of?
I think we discuss that later at the next meeting. April, do you have a sense of how long it takes to prepare an explanatory statement? How about October 7th is a Monday. I could do October 7th at 6 p.m. It is between Rosh Hashanah and Yom Kippur. You can't. What other days of the week work for folks? October 10th. The 15th should be Tuesday after Indigenous Peoples Day / Columbus Day. The 15th, Tuesday the 15th? No, you can't. Junior can't do the 10th. The 23rd, the 16th. The 16th is a Jewish holiday. Is it?
What about the 16th?
It's but it doesn't. It's Erev Shavuot or Erev Sukkot.
What about the?
Right, we could do it earlier in the day. Yeah, I think let's aim for the 16th. Do you want to say? Yeah. Are we available
Plus
during
4 minutes
the working
between
days?
yesterday.
We could do 4 PM?
I like that. I could then go to my writing workshop.
4 PM on October 16th. And I will appreciate if we can get a draft with enough time to really review it. Yeah, I know I'm asking a lot. Is there other business or should we adjourn? Yeah, yeah. Yeah, if there's any issue with getting. Yep. It's like you've done this before, April. I really appreciate it. Um, or like, what's the 28th, 29th, 30th of October? Well, the 28th is a Monday. Do you want to do 6 PM on the 28th as a backup date? Perfect. Yes. Thank you, friends. Appreciate your patience with this. That's the backup date.
At 6 p.m.
And we will have formal notices and then cancel them if needed, and then another formal notice, but we have the dates picked ahead of time. So we'll hold both of those dates. Any other business, or are we ready to entertain a motion to adjourn?
I'll make a motion to adjourn.
Junior makes a motion to adjourn.
Second.
Arlene seconds. Noah, aye. Deanna,
Aye.
Mie,
Aye.
Junior,
Aye.
Michael, Carol,
I
Arlene,
Aye.
Lee.
I
The motion carries. We are adjourned. It is 6:48 PM. Thank you all so much.